Good afternoon, everyone. Welcome to LawPutra YouTube channel, and today we will be dealing with 50 most important MCQs on CPC. So let's begin the session. So question number 1 says that which provision of the code deals with the concept of constructive res judicata? So now all provisions relating to res judicata is given under section 11 of CPC. Alright, now we'll see how constructive res judicata is part of section 11. See, section 11(1), okay, that means subsection 1 of section 11 deals with only what is res judicata, okay, which says that if a matter is already materially and substantially in issue, it cannot be raised in another different suit. Now, constructive res judicata, it basically says that any matter which might and ought to have been made a ground for defense, or attack in a former suit shall be deemed to have been a matter directly and substantially in issue in such suit. It says that let's say that in a particular suit you had 4 points for defense. Okay, that means there was a case filed against you and you have 4 points for defense. Now if due to some reason you only took this one, okay, only first defense, and all these other defenses you did not take up in that particular, now you will be barred from taking these other three defenses also in a separate suit. This is what constructive res judicata says, which that's what it says, which might or ought to have been made a ground for defense or attack. ओके, सो फिर ऐसा नहीं हो कि आप एक दूसरा सूट फाइल कर दो एंड आप उसमें बाद में कोर्ट में बोलो कि जी मैंने तो पहले ये पर्टिकुलर जो डिफेंस था ये लिया नहीं था, सो नाउ आई शुड बी गिवन राइट टू टेक इट. नो, you will not be given this particular right. जितने भी possible defenses हैं which you think will help you for your defense, you have to take it in that particular suit only. So question number 2, in which of the following ways can the court make execution of a decree as per section 51 of the code? So now we know that section 51 of CPC deals with ways in which the execution of an order can be done, right? That means that when an order has been given by the court and that order has not been complied with by the party, then a person, basically the decree holder, he can go to the court and tell the court that please help me to execute this order. So there are various ways in which that order can be executed. This question asks which the court not order execution of decree, which of the following which it cannot adopt. So the options are by delivery of any property specifically decreed, by attachment and sale of property, by serving of summons on the party, by appointing a receiver. So the answer for it is C, which is by serving summons on the party. Now see, this section 51 deals with in all the ways in which an order can be executed. So by delivery of property, attachment of sale, by arrest and detention, by appointing a receiver, these are all given in the section. These are given in section 51 itself. Now it's the option C was serving of summons. See, summons has nothing to do with execution of decree. Summons is basically so that the trial can be initiated. It is basically for the appearance of the defendant or the respondent. Okay, so it has nothing to do with execution of a decree. If a person does not abide by the decree of the court, then the court can order the person to, that either his property can be delivered to the other person or his property can be attached and then can be sold. Okay, and then the proceeds can be used to compensate the plaintiff, or by arrest and detention in the prison. If a person does not basically agree to abide by the court order, then the court can order that judgment debtor to be arrested and be detained in civil prison. So here there's the same thing. Summons are only to compel the appearance of the defendant. Please give me a minute. Yes, sorry. So summons are only to compel the appearance of the defendant and it has nothing to do with execution of the decree. Alright, and section 27 deals with summons, which itself says that summons may be issued to the defendant to appear and answer a claim. Okay, So sir, appear and answer clear, and that's why summons has nothing to do with uh, the execution of decree. So let's say even if you did not know what section or what is written in the execution of decree, just if you even know what is summons, then also you could easily answer that question. The next question is, which of the following properties of the judgment debtor would be liable to be attachment and sale in execution of a decree? So in earlier question I had explained you that attachment is a part in which the decree can be executed, and judgment debtor is the person against whom that order was done, right? And the person in whose favor the decree was done is known as decree holder. So which of the following properties of a judgment debtor would be liable to attachment and sale in execution of decree? So which of these following can be attached by the court, and then let's say it can be sold by the court, so that the proceeds can be used to compensate? So for this, answer is given in section 60. Section 60 provides for property liable to attachment and sale. Property which is liable for attachment and sale in execution of decree. And proviso 60, section 60, it specifically excludes certain ornaments, and which is personal ornaments, tools of artisans, books of account. Okay. And in this question, we were asked which of the following property judgment debtor would be liable to attachment. All right. So in section, it is given in a negative way. It is given as to which cannot be attached. So so automatically that these items cannot be attached. Personal ornaments, tools of artisans, books of account. So our answer would be only shares in corporation can be attached by the court for execution of the decree, and all these things will not be there. So answer is B. And all those items which can be attached by the court, these are all those items. This is also given in section 60 subsection 1. So lands, houses, and other buildings, this can be attached by the court. Okay, then it can sell it. Similarly, goods, money, banknotes, checks, bills of exchange, hundis, promissory notes, these are all basically, you can say that these are all one type of things only, negotiable instruments. All right, government securities, these can also be taken by the court. It can confiscate it and then it can sell it. Then shares in corporation, okay, that can also be basically confiscated by the court and sold. Or any other saleable property, property, movable or immovable, belonging to the judgment debtor, or any other property which belongs to the judgment debtor, whether it is immovable or movable, and which the court can sell. Next question. For which of the following purposes a commission is not issued? A commission is not issued: to make a local investigation, to examine a person, to order a party to appear in court and answer the claim, to make a partition. So the answer is C. The question asks for which of the purpose it cannot be issued. A commission cannot be issued. So answer is C. For the purpose of summons. As I had explained earlier, summons are only so that the person can appear in the court and answer any claim. All right. It has not. This is the only purpose of summon. So that's why summons are not there for commission. And in what cases a commission can be issued? Then that is given under section. Wait. Then that is given under section 75 of CPC, and this is the whole list of items for which a commission can be issued. Next question. What is the time which the court may enlarge in its discretion in a situation where any person is prescribed or allowed by the court for doing an act, for doing an act, not exceeding 60 days in total, not exceeding 90 days in total, not exceeding 30 days in total, not exceeding 20 days in total? So see, in this question it is saying that the a particular act has to be done in a specified time, right? A particular act has to be done. So let's say that a particular act was not being able to done, right? Then court can basically enlarge this particular time. So what is the maximum time which the court can give to basically complete this particular act? So answer is C, and this is given under section 148 of CPC. It says that when any period time is fixed or granted by the court for doing an act, okay, when the court has fixed a particular time, so let us say that a decree has been given in against A, and A has been told to deliver certain properties to B. So let's say court says, okay, we'll give you 20 days. Okay, within 20 days you have to basically deliver this particular property. That means for doing an act, now he's not able to do it. All right, then you have to file an application, and court in its discretion, that means it is not a right, it is complete discretion, the court may, all right, court may enlarge in its discretion, enlarge such period not exceeding 60 days. That means if within 20 days this person is not able to do, then court can give another time for 30 days only. All right, even though the period originally fixed or granted has expired, right? Even though this 20 days has actually expired. So basically on 21st day, the person can go to the court and he can say, okay, so he has to give proper reason that please give me 30 days more. Why 30 days? Because section 148 itself says not exceeding 30 days. That means not more than 30 days. All right. If within 30 days also he is not able to do it, then the person in whose favor the decree was, so the decree holder, he'll go for execution of decree. And then, as I had explained you earlier, either the court will order him that you will be arrested, or that property which was supposed to be delivered, the court itself will confiscate that property and it will sell that property and compensate the other person. Next question. Now, this is a very simple question. Now, whenever it comes to judiciary, there are a lot of questions in which directly they would ask you section numbers, okay, or order numbers. So this can be remembered even if you every day just read the index of a Bail Acts. And Bail Acts are very important. All those questions in this particular test series can be solved easily if you have read the Bail Acts. So, which provision of the code deals with joinder of causes of action? See, causes of action basically means reasons. All right, reasons to institute a suit. Reasons to institute a suit. And joinder of means, let's say if there are multiple cause of action, so all of these can be joined together in one suit. So, which provision of CPC deals with it? So, answer is A. Okay, which is order 2, rule 3. Okay, the title itself of it says joinder of causes of action. Next question. Which of the following is not a suit of civil nature? Now see, this is very important because suit of civil nature comes when you will study section 11, which is res judicata. Alright. So a suit in which the right to property is contested, a suit to which right to an office is contested, a suit by a member of caste for his exclusion from the invitation to the caste dinner, a suit by a member of a caste for his expulsion from the caste. Now, see, suits of basically what are suits of civil nature? Suits of civil nature are those cases in which the main issue relates to private rights and liabilities of the parties. Okay, private rights and liabilities. That means these are those rights which cannot be enforced against society at large. All right. For example, in IPC, all those rights, that right not to be murdered, right not to be hurt, can be enforced against all those persons. But with respect to private right, it is only between two persons. All right. So in which of these suits do you think that private rights are basically involved? Now, as I told you that this is very important because section 11 actually, which is for res judicata. All right. So a civil court has jurisdiction to try a suit if two conditions are fulfilled. A suit must be of civil nature, and the cognizance of such a suit should not be expressly or impliedly barred. So a suit of civil nature means a suit in which private rights and obligations of citizens are an issue, and right to property and right to office are protected by explanation 1 to section 9. So see, these two, the option number A and B, these are expressly given in section 9. These are expressly given in section 9. Okay, so these are basically suits of civil nature. So automatically these can be eliminated. Okay, we have which is not a suit of civil nature, alright, because section 9 expressly it was given. So now we only are left with these two options. So C, a suit by a member of a caste for his exclusion from the invitation to caste dinner. Now see, this particular relates to the caste issue. Okay, this can be enforced against the entire world, okay, the entire society at large. And so that is why the question of private right is not involved in this particular question. All right, a suit by a member of a caste for his expulsion from that particular caste. Now see, in India we can say that okay, that this is a caste issue, but then there are certain personal laws, okay, and if certain personal laws, or let's say certain tribal laws, they have a procedure that a person can be expelled from his caste, okay, then those personal laws will be upheld and they will not be basically suits of civil nature, in the sense that the issue with respect to this particular matter cannot be instituted in a civil court established under CPC. Okay, but if a person is not invited to a caste dinner, now that is a basically issue of society at large. Okay, the whole society is affected. All those persons who are belonging to different caste. So that is why this is a suit which is not of civil nature. So this is the detailed explanation for it. Now, next question. The defendant is required within 30 days from the date of service of summons on him. Service of summons means, let's say that if a case was instituted, okay, then summons has to be sent, okay, so that that person can appear in court and answer his claim. All right. So this whole process of sending the summons, this is known as service of summons. Okay. So defendant is required within 30 days of service of summons on him to present a written statement. However, if he fails to do so within the set period of 30 days, he shall be allowed to file the same on such other day as may be specified by the court, but not exceeding a period of 40, 60, 90, 120 days. So that means 30 days are given statutorily by CPC that a person has to file his written statement. But what if he is not able to file it within those 30 days? All right, then then how many days, then how many extra time, they can extra time kitna milega, of how many days that person can be given. So this is given under order 5 rule 1. Okay, order 5 deals with service of summons. Okay, that means sending of summons. And the proviso to order 5 rule 1 says that where the defendant fails to file the written statement, this is written, not return, written statement within the period of 30 days, he be allowed to file the same on such other day as may be specified by the court. Okay, for reasons to be recorded in writing, but not later than 90 days. Okay, that means if within 30 days he is not able to file his written statement, then court can give him certain time. So let's say 5 more days. Okay, from 31st day. Okay, or 10 more days. But these days cannot exceed 90 days. So that means maximum 90 days can be given to that particular person, all right, to file a written statement. So let's say if a question is asked that what is the maximum time period under the code in which a person can file his written statement, so that will be 30, which is already the person can give, and then plus maximum 90 days. So that means 120 days. So in total, completely a person has 120 days to file his written statement. Next question. A foreign judgment is conclusive as to any matter thereby directly adjudicated upon between the same parties when it has been pronounced by an eminent judge, where it has been given on the merits of the case, when it is written in English, when it has been approved by United Nations organization. So it says that when a foreign judgment is conclusive in India between two parties. So section 13 of CPC deals with foreign judgment, and it says that when foreign judgment is not conclusive, okay, in this question we were asked when foreign judgment is conclusive, but the section says it in a negative way. All right, the negative definition given when it is not conclusive. Okay, and point C, the part C says that when it has not been given on merits. So that means when the particular judgment, the judgment is not on the merits of the case, then that judgment is not conclusive. Now see all those options. Okay, these are very irrelevant question. Okay, when it has been pronounced by an eminent judge, this has nothing to do. Even in India also, there's nothing known as eminent judge. Okay, if it is a judge, okay, and he is a duly appointed judge of a lawful court, okay, then that judgment is a judgment. All right. When it is written in English, now again there might be some many jurisdiction in which the English is not the language, so they will not write it in English. Okay, so let's say Japan, Russia, in all these countries the judgments are in their own languages. When it has been approved by United Nations organization, UNO has nothing to do with it, right? UNO has no power to tell whether a judgment of a particular country is conclusive or not. So the only important question is if where it has been given on the merits of the case. सी अगर मेरिट्स में दिया ही नहीं होगा जजमेंट तो फायदा क्या जजमेंट का, राइट? जो मेरिट्स होंगे वो प्रॉपर जो फैक्ट्स होते हैं केस के वो होते हैं. जब इसमें जजमेंट ही नहीं दिया तो देन द जजमेंट इज नॉट कंक्लूसिव. Next question. Power to amend the issues or frame additional issues prior to passing of a decree vest in the code by virtue of which provision of the code? Okay, Order 14 Rule 1, Order 14 Rule 5, Order 14 Rule 6 or Section 151. So, power to amend issues or frame additional issues prior to passing of a decree. So, let's say now understand what the question is. Before, let's say you have filed a case in a particular court, right? Now before the court can basically go on to adjudicate, okay, it has to engage in something which is known as framing of issues. All right, and in criminal case it is known as framing of charges. So it deals with this only, that so let's say if the court has framed issues, okay, then there might be some new facts which might emerge afterwards. So these issues which were earlier framed then further can be amended. Okay, so this is the question is asking that this power of amendment is given under which provision? So the answer is B, Rule 5. Rule 5 states that the code may at any time before passing a decree amend the issues of frame or amend the issues or frame additional issues on such terms as it thinks fit, and all such amendments or additional issues as may be necessary for the determining the matters in controversy between the parties. So it says that court can frame issues, okay, then it can frame additional issues also, but those issues should be only those which are necessary for determining the matter in controversy between the parties. All other issues, even if court frames, they'll be extraneous, so that can be dropped off. Next question. Where a plaintiff omits to sue in respect or intentionally relinquishes a right any portion of his claim, he shall not afterwards sue in respect of the portion so omitted or relinquished. The genesis of this principle lies in. So see, it says that if the plaintiff has a right to sue, okay, and he omits, he does not basically sue, or either he omits unintentionally or he intentionally relinquishes his that portion of the claim, and afterwards he will not be given a right to basically sue again, okay, for that omitted or relinquished part. So that is given under which part of CPC? So that is given under, or the answer is C. Okay, so we'll see what is option C. So order 2 rule 2 of CPC. So order 2 rule 2 say the relinquishment of part of the claim. Where a plaintiff omits to sue in respect of or intentionally relinquishes any portion of his claim, he shall not afterwards sue in respect of the portion so omitted or relinquished. Okay, so that means if he fails to basically sue for a particular claim, either intentionally or unintentionally, that means omits, then he will not be allowed to do the afterwards. Okay, because the court will deem that the person has waived his right to sue for that particular portion. All right, this doctrine, this waiver concept is also in Contract Act also. Now question number 12. Which of the provision of the code provides that the objection regarding territorial or pecuniary jurisdiction has to be raised as the first available opportunity? Now see, with respect to objection to jurisdiction, one basic principle is that the objection to jurisdiction, whether it be it any objection, okay, whether it territorial jurisdiction, pecuniary or subject matter jurisdiction, it has to be raised at earliest possible opportunity. So that means let's say a suit was filed, all right, and the moment you got that particular plaint, okay, when you file your written statement, it is advisable to file your objection at that point of time only. Okay, these are known as preliminary objections. So that is why it says that which other CPC provides that the objection regarding territorial pecuniary jurisdiction has to be raised as the first available opportunity. So किस सेक्शन में दिया हुआ है कि फर्स्ट अवेलेबल अपॉर्चुनिटी पे ही हमको वो ऑब्जेक्शन को रेज करना है? So the answer is section 21. It itself deals with objection to jurisdiction, whole section 21. And it says that no objection to place of suing shall be allowed unless such objection was taken in the court of first instance, that means the first court or the original court, at the earliest possible opportunity. Okay, so earliest possible opportunity पे choose करना है and वो दिया गया है section 21 में. Next question. On rejection of plaint under Order 7 Rule 11, preventing a fresh plaint in respect of the same cause of action is barred by the principle res judicata on its own force does not preclude the plaintiff from presenting a fresh plaint barred under Order 23, none of the above. So it says that if a person has given his plaint, okay, and due to some reason that plaint was rejected, okay, and the grounds for rejection are given under Order 7 Rule 11. So then whether can he institute a fresh case on the same cause of action? This is given under Order 7 Rule 13, which is answer B. It says that where rejection of a plaint does not preclude presentation of fresh plaint, the rejection of plaint on any ground herein before mentioned shall not on its own force preclude the plaintiff from presenting a fresh plaint in respect of the same cause of action. It means that just because if your plaint has been rejected under Order 7 Rule 11, that does not mean you cannot file a fresh plaint. This is different from the whole concept of res judicata. Okay, so don't confuse it with it. Okay, in res judicata it says that if a matter which was substantially in issue in a previous suit has been finally decided, then the same matter cannot be instituted in a different court. But over here the plaint has been rejected. So if it has been rejected, then that rejection itself will not cause the plaintiff to will not prevent the plaintiff from presenting a fresh plaint in respect of same cause of action. So this is very important. Next question. Which provisions of CPC bars entertainment of applications to review an order made on an application for a review or a decree or order passed or made on a review? Section 11, 10, Order 47, Rule 9 or Order 9, Rule 10, Rule 9. So answer is C. Order 47 Rule 9. It says that bar of certain applications. No application to review an order made on an application for a review or a decree or order passed or made on a review shall be entertained. So see, it basically says that review of a review order shall not be entertained. Okay, let's say that a person that A, and there was a judgment which was which was against him. All right, so he filed for a review. Okay, now in this review also it was upheld that the order against A was valid. All right, then he cannot basically find another review. Okay, that he means he cannot file second review and he cannot say that please review this earlier review. This is what this particular order bars. All right, bar of, so this particular application is not maintainable. Review of a review order cannot be done. Next question. A decree for payment of money passed against a woman cannot be executed by proceeding against her legal representative if she dies, by title of property, by appointing a receiver, by her arrest and detention in prison. Okay, which again read the question. A decree for payment of money passed against a woman cannot be executed. In which of the ways it cannot be executed? So answer is D, by her arrest and detention in prison. And this is given under section 56 of CPC. Despite anything contained in this part, that means section 56, the court shall not order the arrest or detention in civil prison of women in execution of a decree for payment of money. So directly under section 56 only it was given. So answer is D. Next question. The doctrine of res judicata, as contained in section 11, is based on the maxim interest republicate sit finis litium, less non cogit impossibilia, executor juris non habet injurium. So the answer is basically B. The doctrine of res judicata is based on which of the following maxims? All right. So it is based on these two basically maxim res judicata. Okay, interest republicae ut sinit finis means it is in the interest of the state that there should be no end to a litigation, and lex non cogit impossibilia means law cannot compel a person to do possible act. Next question. See, which of the following orders of CPC is related to written statement, set off, or counterclaims? All right. So this is again simple. Which of the following related to set off written statement or claim? So the answer is order 8. Okay. The title of order 8 itself says that written statement, set off, counterclaim. So this question could be easily solved if you just have read the index part also. If you know what is written in the index. Next question. Decree under CPC has been defined in what section? Okay. So decree is defined under what section of CPC? So the answer is section 2. Section 2, subsection 2. Alright. In section 2, the all definitions are given. So in that definition also, subsection 2, it is defined. Next question. Direction of the court to opt for any one mode of alternative dispute resolution, ADR, okay, is provided in. This says that, see, there are, let's say if you that there's one litigation, okay, now if you want to settle this matter out of court, okay, there's something which is known as ADR, alternative dispute resolution. So there are various modes in it, such as arbitration, mediation, right, conciliation, or through lok adalats. All right. So discretion of the court to offer any one mode of alternative dispute resolution. So in which of the provisions, all of these provisions, does the court have discretion to order that the parties go to ADR system for settlement of their disputes? So the answer is Order 10, Rule 1A. It states that after recording the admission and denial, the court shall direct the parties to the suit to opt for either mode of settlement outside the court as specified in Section 89(1). Now see, Section 89, everyone knows that it is related to ADR. Okay, even if you don't study Section 80, Section 80. But they were saying that in which of the orders does the court have discretion to do it? Section 89 सिंपली सेज मोड्स, ठीक है ना, इन्होंने बता दिया कि कौन कौन से तरीके हैं, कौन कौन से एडीआर रिकॉग्नाइज हैं फॉर डिस्प्यूट रेजोल्यूशन अंडर इश्यूज अराइजिंग अंडर सीपीसी. बट वो डिस्क्रिशन जो है कोर्ट में किसके अंदर दी हुई है, तो वो रूल 1A, ऑर्डर 10 रूल 1A में दी हुई है. नेक्स्ट क्वेश्चन. Under which section of CPC clerical or arithmetical mistakes, okay, in judgments, decree, orders, or orders or errors arising therein from any accidental slip or omission made any time be corrected by the court either on its own motion or on the application of the parties? So section 151, 152, 153 or 144. So the clerical or arithmetical mistakes in judgments. Remember, this is judgment. There is another system which is known as amendment of plaint. All right, which is a completely different concept. That is for changes to be made in the plaint. But this is in the order judgment, जो final आ जाता है. All right. So that is basically given under section 152. ऑलराइट. सो इन 152 आइदर द कोर्ट, अगर कोर्ट को लगता है कि भाई जो उन्होंने जजमेंट दी है उसमें कोई स्पेलिंग मिस्टेक है और लेट्स से डैमेजेस देने थे 1 लाख रुपए के लेकिन उसमें गलती से 1 करोड़ रुपए आ गया, राइट, जीरोस एक्स्ट्रा आ गए. सो ऑल दोज मिस्टेक्स can be rectified either on its own motion, that means the court itself can order that the correction be made, or on application by the parties, राइट. दैट मीन जिसके अगेंस्ट में आया है, सो लेट्स से अगर डिफेंड के अगेंस्ट में 1 लाख का ऑर्डर था और उसने देख लिया कि भाई ऑर्डर में तो 1 करोड़ लिखा है, तो वो भी वो एप्लीकेशन डाल सकता है कि प्लीज इसको 1 लाख रुपए कर दो. सो द कोर्ट कैन डू इट. नेक्स्ट क्वेश्चन. वेयर एनी पार्टी डाइज after the hearing and before pronouncing the judgment. Understand one thing, after the hearing and before pronouncing the judgment. एक तो होता है जब when he has died during the pendency of the suit. Alright, कि suit अभी चल रहा था, it was still running and the person has died. Okay, but this deals with hearing and before judgment is pronounced. That means काफी हद तक जो केस है कंप्लीट हो गया है, सिर्फ उसे जजमेंट की प्रोनाउंसमेंट ही रहती है. Then the suit shall abate. Abate means cancel. Okay, don't confuse it with abet जो आईपीसी में दिया होता है. ठीक है. So the suit shall abate. The suit shall not abate. It depends on the discretion of the court whether it shall abate or not. None of these. So the answer is B. The suit shall not abate. वो cancel नहीं होगा. And this is given under Order 22 Rule 1. It states the suit will not abate on the death of a plaintiff or defendant if the right to sue survives. All right. So if the right to sue survives, then even if the person if the either the plaintiff or the defendant has died, the suit will not stop just because of their death. Okay. And if during the pendency of the suit the person dies, all right, now see, right to sue basically mean that you have a particular cause of action. Okay, if you have a valid cause of action, then your right to sue is there. Okay, it is not like that you have a cause of action, then after some reason the right to sue has like gone away. There are very limited reason, but that is not necessary for these kind of questions. Okay, so if the cause of action is valid, then your right to sue is there, and that cannot be taken away from you even if you have died either during the suit or after the suit has completed and only judgment is to be pronounced. Okay, if during the suit the person has died, plaintiff or defendant, then an application is basically moved for appointment of legal representatives, and those representatives, so let's say the sons and daughters, right, and all those relatives, they will basically fight on the behalf of the deceased person. Then again further, Rule 6 of Order 22 says that whether the cause of action survives or not, there shall be no abatement of the suit by reason of death of either party between the conclusion of the hearing and pronouncement of the judgment. So I had told you earlier that cause of action valid हो तो right to sue नहीं ले सकते, but as I told you there are certain very limited reason जिसके अंदर जो है cause of action भी जो है survive नहीं हो पाता किसी reason की वजह से. Alright, so let us say that the property itself has been destroyed, right? कोई earthquake आ गया, and let's say it was a house. Okay, the suit was related to possession of a house. अब वो हाउस ही तबाह हो चुका है पूरा, लेट्स अर्थक्वेक की वजह से, तो कॉज ऑफ एक्शन तुम्हारा डिस्ट्रॉय हो गया, तो सर्वाइव नहीं करता. इन दैट केस आल्सो the particular suit will not abate, okay, just because the death of the party between the conclusion of the suit. So even if cause of action is not there, the suit will not abate and the court has the right to enforce it. Next question. The judgment debtor in execution proceeding raised objection that the trial court had no jurisdiction over the subject matter. Okay, so this deals with, as I told you earlier, section 21 में जो है objections to jurisdiction. So which of the following statement is correct? He cannot raise the objection unless he has raised the same objection before the trial court. He has to challenge the same objection only by way of filing of appeal. He can raise the said objection for the first time in the executing court. None of these. So the answer is basically A. The validity of decree can be challenged in execution proceeding only on the ground that court. Wait. So answer is A. The person cannot raise objection unless he has raised the same objection before the trial court. See, section 21 had said that at the earliest possible opportunity, that any objection, be it with respect to pecuniary jurisdiction or subject matter or territorial jurisdiction, it has to be raised as soon as possible. When it has said that it has to be raised as soon as possible, all right, and it has to be raised at the court of first instance, that is why your Bail Acts are very important. And the court of first instance in all civil suits is basically the trial court, right? High court में हो नहीं सकता, high court appellate court में आ जाता है. So he cannot raise the objection unless he has raised the same objection before the trial court. So see, indirectly basically यही बात बोल रहे हैं कि first कोर्ट ऑफ फर्स्ट इंस्टेंस में होना चाहिए एंड एज सून एज पॉसिबल होना चाहिए. ऑलराइट, he has to challenge him by way of filing appeal. No, this has nothing to do because section 21 ही बोलता है as soon as possible. तो अब अपील के स्टेज का क्यों वेट करोगे? He can raise a said objection for the first time in executing court. Again, this is also wrong. In executing court, the court does not deal with it what is the merits of the case or whether it has the case has been adjudicated properly or not. Simply, if a decree is there, that decree is valid, the court has to give orders for its execution. So here also you have no right to basically raise this plea. So the answer is A. So that is why this was, we can say this is not a very difficult question, but you should have good, you should like know the provisions by heart. Only then you'll be able to do it, because indirectly the answer is A for it. Okay, so the detailed written expression given over here. Now, plea of adverse possession is a defense available only to the plaintiff against the defendant, only to defendant against the plaintiff, both plaintiff and defendant only for movable property. Now see, what is basically adverse possession? Okay, now see, let's say that this is A, this is B, and this is certain property. All right, this for this particular property, the title belonged to A. ठीक है ना, तो दैट मीन्स कोई मान लो सेल डीड हो गई, वो ए के नाम पर है, बट बी इज लिविंग इन दिस प्रॉपर्टी. ऑलराइट, एंड इफ फॉर 12 years B has stayed in this property and A has not raised any objection that why are you staying in my property, then that will be adverse possession. Okay, now there are certain very detailed essential elements for adverse possession, but this is just for your bare understanding as to where adverse, how, what is adverse possession. All right, so this plea of adverse possession, now कल को अगर मान लो केस जो है था कोर्ट में जाते हैं, बी प्ली लेगा ना कि भाई मैं तो 12 साल से इसमें, सो देन कि मैं 12 साल से इस प्रॉपर्टी पोजेशन में था, so that plea is known as plea of adverse possession. So this is available only to plaintiff against the defendant, only to defendant against plaintiff, both plaintiff or defendant, or for any movable property. So the answer is only to defendant against the plaintiff. Now see, there is one rule with respect to adverse possession, that adverse possession can never be used as a sword, can never be used as a sword. It can be used only, it can be used only as a shield. Alright, इस quotation को याद कर लेना, ये this is very important for your adverse possession. So it, that means it can never be used to attack a particular claim, it can only be used as a matter of defense. तो डिफेंस के लिए कौन लेगा? डिफेंडेंट ही लेगा. सो दैट मींस ओनली डिफेंडेंट अगेंस्ट द प्लेंटिफ, एंड प्लेंटिफ नहीं बोल सकता. सो द बेसिक रूल ऑफ एडवर्स पोजीशन इज adverse possession can be used only as a shield and not as a sword. So only defendant can take it. And again, it has to be for immovable property only. All right. So this is also ये भी wrong हो जाएगा. Only for movable property. बिकॉज प्रॉपर्टी है वो, उसका इमूवेबल होना बहुत जरूरी है. मूवेबल प्रॉपर्टी के लिए नहीं आता एडवर्स पोजीशन. देन 24, द रीअप्रिसिएशन ऑफ एविडेंस इन सेकंड अपील, ओके, इज सब्जेक्ट टू रिव्यू, इज परमिसिबल, इज नॉट परमिसिबल, इज एन एडमिटेड फैक्ट. नाउ सी, देयर इज फर्स्ट स्टेज इन विच अ डिक्री वाज पास्ड. ठीक है, सो डिक्री पास्ड, देन यू कैन फाइल एन अपील, okay, which is the second stage. Yagi appeal or first appeal. First appeal. Then against this also a second appeal lies. Okay. Then against this also against first appeal also an appeal lies, and that is known as second appeal. So it says that whether appreciation of evidence appeals or not. So the answer is it is not permissible actually, and we'll explain you why. Now see, reappreciation of evidence during first appeal, that is before district judge, is mandatory. So let's say that the trial court, okay, that means civil judge has basically passed a decree and it goes to district judge, then appeal has to district judge. Then district judge has to consider all those evidence which was basically given in the trial court. Okay, all those evidence again. So as if there's a retrial, but when there is a second appeal which goes to the high courts, then it is not duty bound to consider the evidence once again. All right. Why it is so? Because see, second appeal is basically a creature of statute. Okay, it is not an inherent right. Only first appeal is an inherent right, and second appeal is simply a creature of statute. And so, because it is created by law, by a positive law, so there can be restrictions can be placed on it by the legislature. So that's why reappreciation is not allowed. देन अगेन ऑल्सो इसको और एक तरीका एक लाइक शॉर्टकट है कि हाई कोर्ट में कभी भी जो है एविडेंस नहीं लिया जाता. ऑल राइट, हाई कोर्ट में कभी एविडेंस नहीं लिया जाता. सो लेट्स से कोई भी क्रॉस एग्जामिनेशन जो होगा वो हाई कोर्ट में नहीं होगा. राइट, एग्जामिनेशन चीफ भी हाई कोर्ट के अंदर नहीं होगा. और एनी अदर डॉक्यूमेंट्री एविडेंस द वे इट इज प्रेजेंटेड इन द ट्रायल कोर्ट वो हाई कोर्ट के अंदर नहीं होता. ठीक है ना. बिकॉज हाई कोर्ट में जब भी कोई मैटर जाता है इट ओनली गोज इफ अ सब्सटैंशियल क्वेश्चन ऑफ लॉ इज इन्वॉल्व इन इट. ये हमारे कॉन्स्टिट्यूशन के अंदर में भी लिखा हुआ है, सीपीसी में भी लिखा हुआ है. सो दिस इज द स्पेसिफिक इम्प्लीमेंटेशन ऑफ इट. So let's see, even if you did not know about this thing, then also if you simply had read the constitution, जो हर कोई बंदा फर्स्ट ईयर में करता है, so then you can easily answer this particular question. High Court does not deal with evidence at all. इसमें अगर इसका एक रियल वर्ल्ड इम्प्लीमेंटेशन देखना है, there is a movie by the name of जय भीम. All right, and उसके अंदर ना there is a scene in which the whole court is shocked that वहां पर एक विटनेस बॉक्स लेकर आ रहे हैं, because हाई कोर्ट में तो कभी होता ही नहीं एविडेंस का appreciation of evidence. So next question. A preliminary decree can be passed in a suit for partition, for partnership, for possession and mean profit, all of the above. So now see, we know that CPC में section 2(2) में decree है, and decree can be preliminary and it can be final. ठीक है ना. So in which suit can it be filed? Okay, preliminary decree किस suit में file हो सकती है? अब assuming आपको ये कोई भी आंसर नहीं पता, but you simply know what is a decree, you have the basic idea of decree. All right. So we know that a decree is filed only when there is rights and liabilities involved. All right. And for the adjudication of rights and liabilities, and before the adjudication of rights and liabilities, certain other issues also need to be resolved. So those other issues are resolved in preliminary decree. All right. So the answer is basically all of the above. See, in all those cases, in all these cases for partnership, for partition, partnership, for possession, there are certain rights and liabilities. But in सारों को solve करने से पहले भी there are certain preliminary aspects which need to be established, and those aspects can be established by way of preliminary decree. So this decree can be passed in any suit in which final adjudication is remaining. That is, before passing a final decree, it is necessary for the court to determine certain rights or liabilities. Then the determination of such rights and liabilities shall be a preliminary decree. All right. So now we'll take specific those options. In a suit for partition, a preliminary decree can be which is given under order 2018. Okay, इसमें already दिया हुआ है order 2018 that what is preliminary decree in a suit for partition. It says that if decree relates to immovable property or movable property, the court may, if the partition cannot be conveniently made without further inquiry, then it may pass a preliminary decree declaring the rights of several parties. That means before the partition, before the court can order the partition of the property by way of a final decree, it is required to make certain inquiry to determine rights and liabilities of certain parties. So let us say ये property है, अब इसका partition करना है, 4 लोग हैं, अब इन 4 लोगों में वो कैसे होगा, ठीक है, मतलब कितने परसेंट मिलेगा, वो जो मैटर है ना वो प्रिलिमिनरी डिक्री में फाइल होगा, उसके अंदर डिसाइड होगा. सो फॉर दिस एन इंक्वायरी विल बी मेड फर्स्ट कि ओके ए बी और सी को इतना इतना पोर्शन मिलेगा. वंस दैट इज डन, नाउ द फाइनल एडजुडिकेशन इज वेदर कि इनको ये प्रॉपर्टी दे दी जाए. सो दैट विल डन इन फाइनल डिग्री. सो बिफोर दैट दिस डिटर्मिनेशन ऑफ portion is part of preliminary decree. Similarly, under order 20 rule 15, dissolution of partnership में भी दिया हुआ है. It states the court may pass a preliminary decree fixing the proportionate share of the parties. और that means कोई partnership है, okay, dissolution of partnership है, उसके अंदर हर partnership की जो है कितनी लाइबिलिटी बनती है, तो वो तो उस पर डिपेंड करता है कि उस पार्टनरशिप में से कितना शेयर था. सो दैट फिक्सिंग कि वो कितना पार्ट था वो प्रीलिमिनरी डिग्री का में डिसाइड होगा. नेक्स्ट क्वेश्चन. A suit without service of notice under Section 80 of CPC can be instituted, generally with the leave of the court, in case where urgent or immediate relief is sought with the leave of the court, in case where urgent or immediate relief is sought without the leave of the court, none of the above. So see, Section 80 says that a notice has to be given to government officials. Okay. So a suit without service of such notice can be issued. That means Section 80 तो बोलता ही है कि आपने कोई भी गवर्नमेंट के अगेंस्ट में केस करना है, आपने उसको एक नोटिस सेंड करना है that we will be instituting a case against you. But let's say due to some reason आप ये नोटिस को सर्व नहीं कर पाते हो. Then what? Then can it be instituted or not? So the answer is B. It can be done. That means even without service of notice also, okay, a suit can be instituted against the government servant or any government or public officer if urgent or immediate relief is sought with the leave of the court. Okay, and this exception is basically given under section 82. 81 में general दिया हुआ है. It says that a suit against a government has to be instituted, cannot be instituted after the expiry of 2 months from the date of service of notice. That means अगर आपने मान लो जनवरी में नोटिस दिया तो जनवरी एंड देन फरवरी मार्च में जाकर जो है आप सूट को इंस्टीट्यूट कर पाओगे. 2 महीने का नोटिस जो है इसका एक्सपायर होना जरूरी है. बट ये जो कंडीशन है ये वेव ऑफ कर सकते हैं कब? इफ द मैटर इज वेरी अर्जेंट एंड इमीडिएट रिलीफ इज सॉट एंड दैट टू आल्सो विद द लीव ऑफ द कोर्ट. तो पहले आपको परमिशन डालनी पड़ेगी फॉर द लीव ऑफ द कोर्ट. इफ द कोर्ट considers it urgent or immediate, then the court will basically grant it. So that means then this is also part of essential section 80. So essential section 80 is if it is to obtain an urgent relief with the leave of the court, only a suit can be issued, but relief cannot be granted without serving of notice. Now see, this is an extra point. Under section 80 deals with only with institution of suits. ओके, दैट मीन्स सूट आप इंस्टीट्यूट कर सकते हो, गवर्नमेंट को समन्स वगैरह पहुंच जाएंगे, लेकिन जो फाइनल एडजुडिकेशन होगा ना वो इस नोटिस के बिना पे नहीं होगा. दैट मीन्स यू कैन नॉट कंप्लीटली वेव इट ऑफ. और यानी कि आपने मान लो सूट इन 2 महीने में इशू नहीं करा, आपने मार्च में जाके सूट को इंस्टीट्यूट करा, बट देन फ्रॉम मार्च यू हैव टू सेंड दिस पर्टिकुलर नोटिस अंडर सेक्शन 80. अंडर सेक्शन 80, ऑलराइट. एंड जब तक ये नोटिस इशू नहीं हो जाता मार्च के बाद, देन आप रिलीफ नहीं ले सकते, बट सूट कैन बी इंस्टीट्यूटेड. सो अगेन अनदर इंपॉर्टेंट इज section 80 applies to what? It applies to institution of suits and also for final adjudication also? No, it only applies to institution of suits. Then next question. A decision on an issue of law operates as res judicata. Okay, now res judicata is a Latin term. It says that, let's say that if a particular matter has been decided in a particular suit, then the same particular matter cannot be raised in another suit. All right, ये अपील से अलग है. अपील इज डिफरेंट. अपील आप हायर कोर्ट में जाते हो. जब हम रेस जुडिकाटा की बात करते हैं हम उसमें बात है वो सेम कोर्ट्स होती हैं. ओके, सो लेट्स से इफ देयर इज वन सिविल कोर्ट, देन यू कैन नॉट, एंड यहाँ पे इस पे डिसीजन दे दिया है, देन यू कैन नॉट इंस्टीट्यूट इन दिस सेकंड सिविल कोर्ट. इसमें आप नहीं कर सकते. दिस इज रेस जुडिकाटा. Now we'll see the options. If the cause of action in the subsequent suit, that means the second civil suit में है, is the same as in the former suit, only when the decision on the law point is correct. If the cause of action in the subsequent suit is same as in the former suit, even though the decision on the point of law is erroneous. If the cause of action in the subsequent suit is different from that in the former suit, when the decision on the point of law is correct, or none of the above. Now see, we all know res judicata means if the cause of action in the subsequent suit is same as in the former suit. ठीक है ना? तो इसमें confusion खाली इन्हीं में ही आ रही है. Only when decision of law is correct, only when the decision of law is erroneous, only when the decision of law point is correct. So इसके अंदर basically तो क्या है? It does not matter if the law point is correct or not. Okay, res judicata simply means that if the matter is directly substantial in issue in the subsequent suit, if the parties in the subsequent suit and the former suit are same and they are litigating under the same title, okay, then that particular then that particular suit cannot be instituted in a second suit. It has nothing to do whether decision was correct or not. So that's why the option will be B. Okay, even though the decision on law point is erroneous. Okay, so ये part ना इसमें बहुत important to read this part on all these points very carefully. Okay, because a person can easily get confused, because with one reading only a person can say that all options are very similar, so which one to do. So the person would usually tick mark A, D option, but the answer is B. D नहीं है, B option है इसके अंदर. Next question. After the withdrawal of suit, a plaintiff can institute a fresh suit in respect of the same subject matter, can institute a fresh suit in respect of the same subject matter only with the leave of the court, can institute a fresh suit for the subject matter only with the leave of the high court. यहाँ पे कोर्ट है, यहाँ पे हाई कोर्ट है. सो यहाँ जब कोर्ट बोलते हैं सिविल कोर्ट आ जाती है. ओके, कोर्ट ऑफ फर्स्ट इंस्टेंस अंडर सीपीसी. Cannot institute a fresh suit in respect of the same subject matter unless liberty is given at the time of withdrawal of the suit. So the answer is D. A person can file a fresh claim for the same cause of action after withdrawal, but only if the court has allowed to it. And this is given under Order 23, Rule 1, Kabi sub Rule 3. Okay, where the court is satisfied that suit must fail by reason of some formal defect, that and there are sufficient grounds for allowing the plaintiff to institute a fresh suit. So that means if the court knows that the suit will fail because of a formal defect. Formal defect means, let's say कोई procedural irregularity है, all right, which can be rectified. Then the court will basically tell that person that you please withdraw the suit, आप उसको correct कर लो, and then you institute the fresh one. So इसमें leave the court बहुत important है. So the plaintiff, he has to mention in his plaint that the plaintiff be given the liberty to file a fresh suit. All right. Then the court in its order will also mention that a liberty is given to file fresh suit, and only then a fresh suit can be filed. Otherwise, it cannot be filed. All right. So कोई right ऐसा नहीं है कि आप कर ही सकते हो. It is because it is based on the liberty of the court. Okay, or the leave of the court. There is no right to file fresh suit. Next question. An agreement entered into or compromise on behalf of a minor without the leave of the court under Order 32 Rule CPC is valid, void, voidable against all the parties other than the minors, none of the above. So the answer is C. Order 32 Rule 1 states that no next of friend or guardian for the suit shall, without the leave of the court, enter into an agreement or compromise on behalf of the minor with reference to the suit in which he acts as next of friend or guardian. And now sub rules 2 states that ये तो general rule दे दिया कि कोई next of friend जो है वो कर नहीं सकता, ठीक है ना. But sub rule 2 says that if such an agreement or compromise is entered into without the leave of the court, it shall be voidable against all the parties other than the minor. Okay, so the answer is it shall be voidable. Okay, वैलिड तो होगा ही नहीं, बिकॉज जब वो क्या कहते हैं माइनर के बिहाफ पर था विदाउट लीव ऑफ द कोर्ट, सो वैलिड तो हम ऐसे इसको बोल नहीं सकते. वॉइड कंप्लीटली होगा नहीं, इट इज वॉइडेबल. Next question. An attachment of property shall remain operated under Order 39 Rule 2A of CPC for a period of how many months? So attachment of property, so ये execution से related है. All right. So one of the modes of execution is attachment of property. So this attachment shall remain for how many months? So the answer is C. This is given under Rule 2A. Okay, Order 39, Rule 2A. See, Order 39 जो पूरा है, this is एक है Order 21 and Order 39. These are very two important orders. Okay, and Order 21 तो बहुत ही बड़ा है. Okay, now just make sure that you go through these two orders because these are very important. A lot of questions in a lot of judiciary exams and APP is basically for ADA exams is basically asked from these two orders. So Rule 2 of Order 39 states that If a person causes breach of an injunction and disobeys it, then the court may order attachment of his property and be detained in civil prison. तो ये तो इस क्वेश्चन का ही था, बेसिकली जो जनरल रूल इस क्वेश्चन में दिया गया था कि अगर कोई भी इंजंक्शन ऑर्डर का वायलेशन होता है, then court execution make it can order attachment of his property. But that attachment, then rule sub rule 2 of rule 2a says that such an order of attachment shall remain in force for 1 year, and at the end of the time if the breach continues the property can be sold. That means कि ए है, उसने कोर्ट का जो एक ऑर्डर था इसको बोला भाई तुम कुछ काम करो एंड ए ने नहीं करा, देन कोर्ट विल ऑर्डर द ए की जो प्रॉपर्टी है वो अटैच कर लो, ठीक है ना। अब ये प्रॉपर्टी जो है फॉर 1 ईयर तक कोर्ट जो है इसका कुछ नहीं करेगी, बस अटैच रहेगी, सो दैट ए इज कंपेल्ड टू एग्जीक्यूट दैट पर्टिकुलर ऑर्डर। बट अगर ये तभी भी नहीं मानता, इतना ढीठ है वो, तभी भी अगर नहीं मानता, देन कोर्ट बोलेगी अब तो तुम्हारी गई प्रॉपर्टी, हम तुम्हें 1 साल का भी टाइम दे दिया, अब प्रॉपर्टी हम लोग बेच देंगे वाली। तो वो प्रॉपर्टी को बेचकर एंड जो भी उससे प्रोसीड्स आएंगे विच इज नोन एज सेल प्रोसीड्स, देन कोर्ट कैन यूज दो सेल प्रोसीड टू एग्जीक्यूट इट्स ऑर्डर। ऑलराइट, then again, clerical and arithmetical mistakes in judgments and orders can be corrected under this. We had just done clerical and arithmetical mistakes in judgments and orders, okay, not in the plaint. It can be done under section 152. And इसका बाकी दूसरा क्या है, either court on its own motion or on an application of the parties, on an application of the parties, ठीक है ना। आइदर दिस और दैट, कोई भी दोनों में से में कोट कर सकती है। सो सेम सेक्शन 152 डील्स विद अमेंडमेंट ऑफ जजमेंट एंड डिक्रीज। नेक्स्ट क्वेश्चन, ड्यूरिंग द पीरियड ऑफ कंक्लूजन ऑफ हियरिंग एंड प्रोनाउंसिंग ऑफ जजमेंट, इफ आइदर पार्टी डाइज अंडर ऑर्डर 22 रूल 6, then the proceeding shall abate. The proceedings shall not abate irrespective whether the cause of action survives or not. It is in the discretion of the court to order abatement or non-abatement, none of the above. Again, this we have just done, and इसको बस थोड़ा सा और indirect way में दिया हुआ है। Alright, थोड़ा सा confusing बनाने के लिए। So conclusion of hearing and pronouncing of judgment if a party dies. Okay, पहले ही बताया था abatement तो होगा नहीं, ठीक है ना। यू एक बार राइट टू सू आ गया तो आप अबेट नहीं कर सकते। द प्रोसीडिंग शेल नॉट अबेट इररिस्पेक्टिव वेदर द कॉज ऑफ एक्शन सर्वाइव्स और नॉट। दिस इज द राइट आंसर, ठीक है ना। बिकॉज सी देखो पूरा ट्रायल तो हो गया ना, अब क्या मतलब बनेगा इसको अबेट करने का। इसके पीछे हम लेट्स से इफ वी गो बाय द आइडिया बिहाइंड दिस रूल, देयर इज नो रीजन टू कैंसल दोस प्रोसीडिंग्स। ऑलराइट, सो द प्रोसीडिंग शेल नॉट अबेट इररिस्पेक्टिव वेदर कॉज ऑफ एक्शन सर्वाइव्स और नॉट। So the answer is B, and this is given under order 22 rule 6. Whether the cause of action survives or not, there shall be no abatement by reason of death of either party between the conclusion of the suit. So death of either party between the conclusion of hearing and pronouncing of judgment. Okay, because see final stages पे there is no reason to not basically to stop the proceeding. Otherwise जिनके favor में वो proceeding थी ना, there will be loss to them. Right, in justice and equity बोलती है if a trial has been done, right, उनके फेवर में आ गया है, कोर्ट ने रिकॉग्नाइज भी कर लिया है, then if you will cancel those proceedings, then this is against the principle of justice, equity and good conscience. Next question, where decree is silent as regards to further interest, okay, then further interest shall be deemed to have been refused and a separate suit shall not lie for the same. Further interest shall be deemed to have been refused and a separate suit shall not lie. Only A is correct, none of the above. So answer is B. This is given under section 34 rule 2. Okay, अब section 34 simple deals with interests, and sub rule 2 says that where a decree is silent with respect to payment of further interest on such principal sum from the date of decree to the date of payment or earlier date, the court shall be deemed to have refused such interest and a separate suit therefore shall not lie. That means अगर किसी पर्टिकुलर सूट में लेट्स से पेमेंट ऑफ मनी का था, ठीक है ना, एंड उसमें कोर्ट ने कोई इंटरेस्ट नहीं दिया, ठीक है ना, उसने बोला कि जो आपकी पेमेंट ऑफ मनी है फ्रॉम द डेट ऑफ डिक्री टू द डेट ऑफ पेमेंट, इस पे आपने कोई इंटरेस्ट नहीं देना, तो it will be deemed that कोर्ट ने उसको रिफ्यूज कर दिया है. ऑल राइट, सो दैट मीन्स अब इसमें ये भी एक चीज समझो, फ्रेश सूट नहीं फाइल होगा दैट ओके व्हाई नो इंटरेस्ट हैज बीन गिवन ऑन इट. नो, fresh suit is not maintainable. Why? Because of this section, because court has deemed that it has refused the payment of such interest. Now, question 36. A decree is passed against the Union of India or state. The execution of it, the execution shall, unless it remains unsatisfied for a period of dash, computed from the date of such decree. 2 months, 3 months, 1 month, 6 months. So it says that if a decree has been passed against Union of India or state and उसकी execution जो है it remains unsatisfied for a period of how many months computed from date of such decree. This is given under section again 82. Okay, answer is 3 months. Execution of decree against the government or public officer shall not be issued on any such decree unless it remains unsatisfied for a period of 3 months from the date of decree. So see, it says that कि अगर आपने section 82 में आपने एक सूट फाइल करा, sorry section 82 नहीं, section 80 में have given the notice and आपने सूट फाइल कर दिया against the government and the decree was in favor of the private person against the government, then some time needs to be given to the government to execute that decree. Government अपनी तरफ से भी कर ले. So that is for 3 months. That means 3 months time has to be given, and even if after the expiry of this 3 months the decree remains unsatisfied, only then an execution can be filed against it. Next question. Question number 36. As per Order 21, Rule 57 of CPC, if court omits to give direction regarding attachment, attachment shall be deemed to have ceased. Passes an order upon the death of the decree holder, passes an order upon the death of judgment debtor, passes an order dismissing the application for execution in all these circumstances. So the answer is passes an order dismissing the application for execution. It says that where any property has been attached in execution of a decree and the court for any reason passes an order dismissing the application for execution of the decree, the court shall direct whether the attachment shall continue or cease and shall also include the period up to which such attachment shall continue or the date on which such attachment shall cease. Alright, so answer is C. Next question. Pleadings to state. So simple say that pleadings क्या state करती हैं? Facts of law, facts with evidence of the suit, material facts and not the evidence, facts with description of the witness. So the answer is C. This is given under Order 6. See, Order 6 deals with pleadings generally. Pleadings generally. Okay. बहुत ही बेसिक प्रिंसिपल्स देते हैं विद रिस्पेक्ट टू प्लीडिंग्स एंड उसमें सबसे पहला ही रूल बोलता है और एंड इवन द टाइटल आल्सो सेज दैट प्लीडिंग्स टू स्टेट ओनली मटेरियल फैक्ट्स एंड नॉट द एविडेंस. सी प्लीडिंग्स बेसिकली क्या होती हैं? प्लीडिंग्स इज प्लेंट एंड रिटन स्टेटमेंट. ऑलराइट, एंड ये दो फाइल करी जाती है एकदम सबसे पहले एट द फर्स्ट स्टेज ऑफ द सूट. ओके, व्हेन द कॉज ऑफ एक्शन अराइजेस, जब आपकी एकदम पहली हियरिंग होती है, पहली तो जैसे अपीयरेंस की होती है, ठीक है ना, उसके बाद ही प्लेन रिटन स्टेटमेंट वगैरह कंसीडर किया जाता है. तो you have to state only the facts and not the evidence, because the evidence, to state evidence ना, there is a separate stage of evidence. This is basically more this, ये जो है ये एग्जाम पॉइंट ऑफ व्यू से इंपॉर्टेंट नहीं है, जस्ट फॉर पर्सन गोइंग टू प्रैक्टिस. सो एविडेंस स्टेज में जाके आपका सारा एविडेंस वाला मैटर आता है, ठीक है ना. फर्स्ट स्टेज में प्लीडिंग्स की स्टेज में आपने नहीं करना. सो प्लीडिंग्स टू स्टेट ओनली मटेरियल फैक्ट्स एंड नॉट द एविडेंस. ये जो एविडेंस होगा वो एविडेंस की स्टेज पे जाएगा. Then question number 39, which is correct with respect to Order 18, Rule 17 of CPC? The court may put such question to witness as the court thinks fit. The counsel of opposite party may put questions to witness as thinks fit, but the witness should not be a party in the suit. Only the witness who appeared to produce the document can be recalled. Parties may put such question as they think fit. Please give me 5 minutes. Okay, so the answer is A. Order 18 Rule 17 says that the court may at any stage of the suit recall any witness who has been examined and may put such questions to him as the court thinks fit. Okay, so let's say the person has already been examined and now again some question need to be asked. So the court can basically recall that particular person. Okay, so order 18 rule 17 deals with persons who have been already examined. Okay, and कोई further question court को पूछना है. This is not it like this will not be second examination. Okay, जैसे first examination तो बहुत detailed में होगा proper. Okay, but court जब questions पूछता है तो तब उसके अंदर हम लोग बोलते हैं, तो वो दो पावर दी गई है ऑर्डर 18 रूल 17 के अंदर. ऑलराइट, एंड जो फर्स्ट एग्जामिनेशन होता है वो बेसिकली एग्जामिनेशन चीफ होता है. नाउ क्वेश्चन नंबर 40. A is residing in Delhi. Okay. A who is residing in Delhi beats B in Calcutta. All right. Here in this case, suit for wrong done to B can be filed by B against A. So that means A है, ठीक है, and ये B है. अब A ने भाई B को मार दिया, beat up, ठीक है. A रहता है दिल्ली में और ये जो इंसिडेंट हुआ बीटिंग अप ये हुआ कैलकाटा में. अब इस कोर्ट में जो है हमारा सूट फाइल होगा, वेदर इन दी कोर्ट ऑफ दिल्ली और इन दी कोर्ट ऑफ कैलकाटा. तो ऑप्शन जो दिए हुए हैं, ओनली इन कैलकाटा वेयर बी इज बीटन अप बट नॉट इन दिल्ली, ओनली एट दिल्ली वेयर ए इज रिसाइडिंग बट नॉट इन कैलकाटा, आइदर कैलकाटा और दिल्ली, नाइदर कैलकाटा और दिल्ली. तो इसमें देखो ये तो अब ऑलरेडी डी तो वैसे एलिमिनेट हो सकता है, ठीक है ना, कहीं तो फाइल होगा. सो डी हैज बीन एलिमिनेटेड. वी आर ओनली लेफ्ट विद दीज थ्री ऑप्शंस. Now, section 19, this given under section 19, it says that suit for compensation wrong to done for movables. Now, it says that section 19, if the wrong was done within the local limits of jurisdiction of one court and the defendant resides or carries business within the local limits of jurisdiction of another court, the suit may be instituted at the option of plaintiff in either of the said courts. ठीक है ना, यानी कि अगर डिफेंडेंट जो है एक पर्टिकुलर कोर्ट के जुरिस्डिक्शन में रहता है और जो कॉज ऑफ एक्शन है यानी कि जो मारा था, जो बीटअप हुआ था, दैट इज इन अ डिफरेंट कोर्ट जुरिस्डिक्शन. ओके, सो यहाँ पे जैसे था कैलकाटा और यहाँ पे था दिल्ली, सो या तो दिल्ली में भी कर सकता है, कैलकाटा में भी कर सकता है. ओके, एंड दिस इज बेसिकली क्वेश्चन विच इज द डायरेक्ट इलस्ट्रेशन. ए रिजाइडिंग इन दिल्ली बीट्स बी इन कैलकाटा, बी में सू ए आइदर इन कैलकाटा और दिल्ली. And that is why your bare acts are so important, because directly illustration में से वो लोग question पूछ लेते हैं. So even if let's say you did not know the whole provision, but थोड़ा सा बस idea ही होता है illustrations का, then you can easily solve this one. Then next question, and question number 41 के बाद जो थोड़े से हैं questions, I guess 3 से 4 हैं, they are related to decree, and see decree is actually very important because pretty much in all examination, be it judiciary, okay, or be it higher judicial services, or be it the exam for ADA, okay, decree में the question आया ही आया है, okay, directly में and indirectly भी, and काफी simple भी है. Decree से questions is not so difficult and a person can easily do it. So decree is very important. Under CPC, which of the statement is not correct? Not correct. Decree includes the rejection of plaint. Decree includes determination of any question under section 144. Decree does not include an order of dismissal for default. Decree includes an adjudication from which an appeal lies as an appeal from an order. Now read this question properly, because the question is actually very simple, but just the way in which this question has been worded makes it a little bit confusing. Okay, otherwise this is very simple. Okay, so आंसर इज बेसिकली डी. सी उन्होंने पूछा था विच ऑफ द फॉलोइंग इज नॉट इंक्लूडेड इन डिक्री, राइट, विच ऑफ द फॉलोइंग स्टेटमेंट इज नॉट करेक्ट विद रिस्पेक्ट टू अ डिक्री. अब जो सेक्शन 2 डिक्री में डिफाइन गया, सेक्शन 2 सबसेक्शन 2, अ डिक्री डज नॉट इंक्लूड एन एडजुडिकेशन फ्रॉम विच एन अपील लाइज एज एन अपील फ्रॉम एन ऑर्डर और एन ऑर्डर ऑफ डिसमिसल ऑफ सूट. बट यहाँ पर जो ऑप्शन दिया था डिक्री इंक्लूड्स डाला इन लोगों ने, ऑप्शन डी में डायरेक्ट डिक्री इंक्लूड्स, लेकिन जो सेक्शन 2 सबसेक्शन 2 बोलता है अ डिक्री डज नॉट इंक्लूड एन ऑर्डर ऑफ एजुडिकेशन फ्रॉम विच एन अपील लाइज, राइट. बट यहाँ लिखा हुआ है includes an order of adjudication from which an appeal lies. So the answer is B, which is not correct. Okay, this is not a part of decree, but the option says that it includes to be a part of decree. So again, the answer is the question was very simple, but just the wording of it was complicated. Again, question number 42. Decree includes rejection of plaint, any adjudication from which an appeal lies as an appeal from an order of dismissal for default. Abhi, we had just studied a decree does not include adjudication from which an appeal lies, an order for dismissal of suit. So ये दो तो अपने आप ही हट गए automatically because यहाँ पूछे includes. So the remaining answer is the rejection of plaint. Okay. Now we'll go to the section. So section 2 decrees of formal adjudication. Decrees and formal adjudication as far as courts expressing it conclusively determines the rights of the parties with regard to all or any of the matter in controversy in the suit and may either be preliminary or final, and it shall deemed to include rejection of a plaint, determination of question under section 144, but shall not include these two. So rejection of plaint is deemed to be a decree because it has been deemed to be included in it. Next, question number 43. Cause of action may be described as, see, cause of action basically means reasons to institute या to file a suit और a case. एकदम simple terms में कोई reason होना चाहिए, ठीक है ना. Cause of action नहीं होगा, that means there is no reason. The court under order 7 rule 11 can reject it. So what is cause of action? अभी मैंने को पता है reasons to file it. So क्या वो bundle of essential facts है which is necessary for the plaintiff to prove an important subject of litigation, an important point in question, all of the above. So see, the correct answer is it is a bundle of essential facts which is necessary for the plaintiff to prove. जो reasons है, जो cause of action, it is necessary for the plaintiff to prove that वो cause of action accrue हुआ है उसके favor में, उसके against में. So these are those bundles of essential facts. Okay, I guess थोड़ा सा question जो था up down हो गया. हाँ. So the cause of action is the reason to initiate the suit. Reasons, and what are reasons? Reasons are the material or essential facts of the case. All right. So that is the cause of action. Next question. Among the following, in which section the term decree is defined? Okay. Section 2 subsection 1, section 2 subsection 2, section 2 और section 2 यहाँ पे D होना चाहिए था, यहाँ पे आ गया. So the answer is section 2 subsection 2. Okay, decree is defined under section 2 subsection 2 of CPC. ये इसको याद ही कर लेना. 2 subsection 2, right? Then what is order 21? What is order 39? Right? Objections जो है वो किस में दिए हुए हैं, तो वो section 21 में दिए हैं. Res judicata किस में दिए, section 11. So these are some of the few sections जिनके section number just remember it. Next question. Section 9 of the code confers jurisdiction in civil matters, political matters, religious matters, either A, B or C. So section 9 basically deals with suits which are expressly barred. The explanation to it says that a suit in which right to property or to an office is contested is a suit of civil nature, despite that such right may depend entirely on the decision of the question as to religious rites or ceremonies. See, section 9 basically deals with jurisdiction of civil court. Okay, that means जो civil court की jurisdiction है वो किन matters में है, and it says that the jurisdiction of civil court is there only for those suits which are of suits of civil nature. All right. Now political matters and religious matters, ठीक है ना, these are suits which are not of civil nature. All right, because इसमें जो question involved होता है, बिकॉज इसमें जो क्वेश्चन इन्वॉल्व होते हैं रिलीजियस मैटर्स एंड पॉलिटिकल मैटर्स में, वो प्राइवेट इंडिविजुअल के में नहीं होते. जैसे मान लो ए और बी के बीच में नहीं होंगे सिर्फ वो, लेट्स से कोई एक पार्टी होगी ए और बी एंड अगेंस्ट द होल वर्ल्ड, उनके अगेंस्ट में होंगे, राइट. सो लेट्स से कोई रिलीजियस मैटर है, सो लेट्स से विद रिस्पेक्ट टू एंट्री इन अ पर्टिकुलर टेम्पल, सो दैट इज अ रिलीजियस मैटर, सो वो तो पूरे वर्ल्ड के अगेंस्ट में हुआ. Similarly, political matter against the whole world होगा, whether a person can be allowed to be contested in a particular election, right? So वो भी उसी के अंदर आएगा. So that means only for suits of civil matters. Now jurisdiction under CPC lies only if it is of civil nature, but more involvement of religious or political aspect does not take away civil nature of the suit. So let's say that there is a suit of civil nature, and in order to decide it, a particular question with respect to religious rites or ceremonies or any political question has to be decided. So just because कि वो एक थोड़ा सा aspect आ गया religious का, it does not strip away the that particular cause of action of its civil nature. Only pure religious and political issue and by section 9. Okay, जिसमें सिर्फ और सिर्फ and purely religious and political matters हैं. Next again ये section 9 से ही related है. A civil court has jurisdiction to try a civil suit unless its cognizance is expressly or impliedly barred, either A or B, only A or B. So the answer is either A or B. Section 9 itself makes it clear. Okay, the courts shall, subject to provisions of CPC, have jurisdiction to try all suits of civil nature except suits of which their cognizance is expressly or impliedly barred. Expressly means एकदम directly दिया हुआ है कि नहीं करना, and impliedly means अगर indirect way में दिया हुआ है. So जो हमने यहाँ पर देखा था for political and religious matters, so see this is actually impliedly barred. ठीक है ना, ये इसमें impliedly, because जब हम section 9 पढ़ते हैं, if you study it in detail, one of the essentials is that the suit has to be of civil nature. Okay, and civil nature में then you will study what is a civil suit, that is it is suit between two private parties. So उसमें ये दो aspects नहीं आते, so it is impliedly barred. Next question. Jurisdiction of a court depends on averments in a plaint, defense in the written statement, both A and B, and above, none of the above. अब इसमें बोला jurisdiction of the plaint. Jurisdiction का एक rule है that jurisdiction is to be decided based on the pleadings of the parties, and pleading